All right, what if you could win a legal battle before you even set foot in a courtroom? I'm not talking about having louder arguments or fancier lawyers. I'm talking about using superior intelligence. Today, we're going to break down a legal fight that was treated just like a military campaign, where the real weapon wasn't a law book. It was a battle plan.
And this quote, wow, it just perfectly captures the two mindsets that are about to crash into each other here. You've got one side that's, basically just using weapons somebody else built for them. They're playing checkers. And then you've got the other side. They're playing chess. They're thinking 3, 4, even 5 moves ahead.
So the first step to outmaneuvering anyone really is to understand them. You can't just know what they do, you gotta know why they do it. So that's what we're going to do. We're going to deconstruct a legal battle plan, piece by piece, and find the patterns, the little tells, that make even a tough opponent completely predictable.
Okay, and to do this, we're actually going to borrow a tool straight from military intelligence. It's called TTPs. Now, that stands for Tactics, Techniques, and Procedures, which sounds kind of complicated, right? But really, you can just think of it as the other side's playbook. And once you have their playbook, well, you can start calling their plays before they even run them.
So when you really analyze this opponent's past moves, a pattern starts to emerge, and it is chillingly clear. This isn't just random chaos, not at all. It's a very carefully orchestrated 3-step attack. It's designed to do one thing: corner and crush a target. And we're calling it the escalation ladder.
And here it is, laid out for us. This is their entire game plan. It starts with what we're calling the mediation trap. It looks like an offer to talk, but it's really designed to lure you in and get you to sign a gag order, basically to legally shut you up. If that doesn't work, bam, they move to step 2, the incapacitation attack. This is where they file a motion for a psychiatric evaluation, not out of concern, but as a weapon to just destroy your credibility and sever your parental rights. And if that doesn't work, they pull out the big guns, legal warfare by proxy. They try to get criminal charges filed to finish the job. It's a brutal playbook for sure, but it's also predictable. Okay, so picture this. You know their playbook, you've studied it, you know every move they're going to make. And then, out of the blue, an email lands in your inbox. It looks like an offer of peace, an olive branch. But is it? Or is this the bait for the exact trap you've been preparing for? And there it is, December 22nd, 2025. A new communication arrives. And let me tell you, this letter, it's not just a piece of paper. It is the first shot fired in a brand new battle. It's the trigger for the entire counteroffensive that we're about to see unfold. So what's inside this letter from Attorney G. Troy Pickett? Well, the demands are pretty straightforward. First, they want you to start paying their client's rent, to the tune of $2,549 a month. And second, they want you to agree to attend mediation to resolve the case. Seems simple enough, right?
I mean, on the surface, this seems like a pretty reasonable offer to de-escalate, doesn't it? Paying some money, agreeing to talk. But is it? Remember the playbook we just talked about. Is this a genuine offer? Or is this the moment the trap is being sprung?
And this is exactly why you have to be thinking 3 steps ahead. See, any normal response here is a trap. Check this out. If you just ignore it, well, then you're portrayed as irresponsible and uncooperative. If you respond directly to the lawyer, you get dragged right back into the lower court's fight, which completely undermines your Supreme Court case. And what if you agree to mediation? You walk straight into that trap we identified, the one designed to force a gag order. Even the venue is a trap. By responding to them on their terms, you're basically acknowledging the lower court's jurisdiction. It's a brilliant 4-pronged ambush. No matter what you do, you lose.
So what on earth do you do when every single move leads to a trap? Simple. You don't play their game. You flip the whole board over and create a new one. This isn't about responding. It's about launching a full-blown counteroffensive.
And here is the game changer. The response isn't a letter. It's not an email. It's a formal, public filing sent directly to the Supreme Court. It's called Relator's Fifth Supplement. Think about that. With one single move, the entire narrative is seized. The battlefield completely changes, and the opponent is instantly thrown on the defensive.
Yeah, this filing is so much more than just a legal document. It's what the military would call a CONOP. It stands for Concept of the Operation. And that's exactly what it is. It's the commander's formal plan for the mission. It's the battle plan for the counterattack, laid out right there in the open for everyone to see.
So let's break down this CONOP. It's a 4-step plan. Step 1, reframe. You take their demand for rent money and you reframe it as an admission that the child is in danger.
Step 2, expose. You use hard evidence, real intelligence, to expose their mediation offer as nothing but a bad faith trap. Step 3, escalate. You elevate this from a simple family court issue to a matter of constitutional importance. And finally, step 4, control. You seize control of the venue by demanding that all future communication happens at the Supreme Court. Brilliant.
Okay, but a plan this brilliant, this audacious, it all hinges on one critical thing: proof. You can't just walk into the Supreme Court and say, hey, this is a trap. You have to prove it beyond a shadow of a doubt. And that is where the hard intelligence comes into play. The anatomy of coercion.
The entire counteroffensive really depends on being able to prove that this mediation offer is a known trap. The goal is to show the court, look, this isn't a new tactic. We've seen this before. It's the same coercive move they've tried in the past. But this time there are receipts.
And here it is, the proof, the smoking gun. It's a certified transcript of a conversation that was recorded way back on June 30th, 2025. This single document is the piece of evidence that's about to blow their entire strategy wide open.
So inside this transcript, a very simple, very direct question gets asked. Listen to this. Rinaldo asks, if we had mediated and reached an agreement, then they wouldn't have made me undergo a psychiatric evaluation?
The answer that came back, one word. Correct. That's it. That's the knockout blow. A direct admission on the record that the psych eval was never about mental health. It was a bargaining chip.
And just to make it crystal clear, the follow-up question nails it down. Rinaldo says, so the psychiatric evaluation is a weapon, not a tool for diagnosis, a weapon.
And this is how you use intelligence to win the war. That one admission, from months ago, recorded and transcribed, it gets deployed in this new Supreme Court filing. And it proves definitively that this new offer for mediation isn't made in good faith. It's just another coercive litigation tactic. It's a complete, systematic dismantling of their entire strategy, using their own words against them.
So, what's the big takeaway here? I mean, we've just watched a brilliant ambush get completely dismantled by an even more brilliant counterattack. But the lesson here, it's bigger than just this one legal case. Let's go back to that thought from the very beginning. I would think in reality war-making would be more of an intellectual or academic exercise. This whole battle, it wasn't won with brute force. It was won with foresight, with analysis. It was won simply by having a better plan. It really was. War is an intellectual exercise. Which leaves us with one final question to think about. In any conflict, what's really the more powerful weapon? Is it force or is it foresight? The next time you find yourself facing a challenge, ask yourself that. Are you just playing with the pieces you were given, or are you thinking 5 moves ahead? The answer to that, well, it could be the difference between winning and losing.